Good morning, everyone. Thank you for being here. I'm excited that you're all here, and I'm thrilled to be able to be here with our distinguished panelists who will be talking today about money bail and the bail system in California. I'm Rob Bonta. I'm honored to serve in the California State Assembly. I represent the 18th Assembly District, the great cities of Oakland, Alameda, and San Leandro, and I'm also very proud to be the chair of the Select Committee on the Status of Boys and Men of Color. And the goal of the Select Committee is to improve the life outcomes of boys and men of color throughout the state, and specifically to give a voice to that population of boys and men of color who are locked in, locked out, or locked up. And instead of locking up our boys and men of color in jail or in prison, we're working to unlock their genius, their talents, their creativity, their brilliance by directly addressing and taking on some of the complicated social and economic criminal justice inequities that are blocking boys and men of color from living their full potential. California in the Select Committee is a leader on justice issues, from tackling mass incarceration and unjust sentencing laws to finding alternatives to unfair school disciplinary rules, from helping students heal from trauma, the trauma of living with violence and adversity, adverse childhood experiences, to leading the fight against implicit bias and excessive police force by law enforcement. We've taken on quite a few issues that we believe help bring more justice to our state. And today we're bringing to light another significant obstacle to justice, California's bail system. And I'm proud to have today brought the experts, advocates, and community leaders together today to assess the system and describe their own experiences and their own work, their own analyses. But I can't emphasize enough the fact that, in my view, the current system is broken. And I hope we can all agree on that today following the robust discussion that we'll have. The purpose of the bail was to provide a path for an individual to go back to their life while they await trial, with the guarantee that they would return for their court date. It's not happening that way today. Instead, if you have the money to pay, you can get out no matter how dangerous you are. If you are poor and can't pay bail, you will sit in jail, even if your violation is something as minor as a traffic ticket. Again, the system isn't working. Our bail system jails tens of thousands of people in California for being poor. Our bail system fails to adequately assess defendants' public safety and flight risks. And our bail system costs millions in taxpayer dollars each year. In my view, it's not a question of if the system needs to be reformed, it's a question of how. And that's why we're here today, to find the best path forward. And I'm committed to making this coming year the year that we pave a new path, a better path, through smart, effective, and comprehensive reforms to California's bail system. And with the commitment that the experts, advocates, and community leaders and voices here today will be supportive in that work, I'm confident that we can and we will be able to make the reform that we need here in the state of California. So with that, I'd like to introduce one of my amazing colleagues, the chair of the Senate Public Safety Committee, longtime leader throughout the state and throughout this nation, Senator Lonnie Hancock, who's been a friend and an ally on this issue for a very long time. I'm honored to team up with her today, and pleased to provide you an opportunity to provide any remarks that you like. Senator Hancock.
Well, thank you very much, Rob. I'm not going to say Assemblyman Bonta, but I am so delighted to be here. I want to learn with you today. Some of you may know that 2 years ago, I did a bill on bail reform. I carried it past the state Senate. It failed by a couple of votes in the state assembly, and at the time, we happened to have an assembly member who was in fact a bail bondsman. And he made his, a major priority of his making sure that the bill didn't get out. But in the meantime, we've really continued and strengthened a national conversation about bail reform. This isn't just California. Across the country, we're seeing that it is a system that simply penalizes people for being poor. So it's time to take it up again, and today will be, I think, an excellent opportunity for us to get some of the best thinking on this. I'm like really happy to see today one of the people in the audience, Robin Lipitsky, our public defender in Contra Costa County. They've been doing a pilot for the last about year and a half, working with the courts and the DAs to try to show that these alternatives really are viable, and they can be as simple as a reminder phone call or child care for making your court appearance. I would just note also that in the last 6 years since I've been chairing the Public Safety Committee, the state has invested over $1 billion in jails, building jails, more jails, adding on to the jails that we have. If we could spend the same amount of money on alternatives to incarceration, I think we would get a much greater return for our dollars. So I'm really honored to be working with Assemblyman Bonta, because he will move forward with a bill, and there'll be a real opportunity for us to make the change that is needed. So thanks very much.
Thank you, Senator Hancock, for your leadership and partnership today. I also want to acknowledge Assemblymember Tony Thurman's office is here today. Can you raise your hand? And if any other colleagues come in to join us today, please let us know. We're proud to be working together on this issue. I also wanted to just let you know we're going to have we have all of our panelists up at the dais right now. I'll be introducing the groups that constitute our separate panels in sequence. But I also want to just let folks know that at the very end, we will have a very significant amount of time for public comment. So we want to hear from you. We want this to be a dialogue, a discussion, where you're not just being talked at, but that we're participating in a discussion and dialogue together. So we're going to have 45 minutes of public comment at the very end. And during the course of the panelists speaking, we're going to have time cards indicating how much time that you have. So please follow those so that everyone gets a fair amount of time to speak and everyone can be heard today. We have a lot of folks. We think this is a really important issue. We want to get all the voices in the room, but all the voices can only be heard if we are strict about sticking within the time limits. So with that, I want to go to our first panel on the fundamentals of California's bail system. We have 15 minutes dedicated for that, and we have Eve Hirschkoff, Judicial Council of California, and Professor David Ball, Santa Clara University School of Law, here to participate on that panel. And without further ado, I turn it over to Eve and David.
Thank you, Assemblymember Bonta, for inviting me to participate in this special hearing. I've been asked to provide a brief overview of the bail system in California, and as many of you already know, it is a complex system. I want to start by mentioning the main sources of law that govern the bail system. There's constitutional law, including the 4th and 8th Amendments to the United States Constitution, as well as Article 1, Section 12 of the California Constitution, many sections of the California Penal Code, and court decisions that address bail and pretrial release. One of the foundations of American criminal law is the presumption of innocence. The law presumes that a person arrested and charged with a crime is innocent until proven guilty in a court of law. Given that presumption, California law provides 4 options for pretrial release: release on bail, release on a person's own recognizance, which I'll touch on a bit later, release under supervision, and pretrial diversion. The term bail is used in several different ways in California law, but I will use the most common definition as bail allows someone who has been arrested, a defendant, to be released from actual custody, that is from jail, based on providing a cash deposit, a bond, or some other type of security that is considered necessary to guarantee that the defendant will appear in court for hearings on his or her case, and that will also assure public safety. The term cash bail or money bail is used when talking about a defendant putting up money to be released. When bail is in the form of a security, the term surety bond or bail bond is typically used. When a defendant puts up bail, whether a cash bail or bail bond, and is released from custody, that is called admission to bail or bailing out. In terms of who has a right to bail, a defendant who is charged with any offense other than an offense that carries the death penalty as punishment has a right to bail. The California Constitution places limits on the right to bail in two other situations: in cases where a felony defendant has threatened great bodily harm to another, or where the defendant is charged with a violent felony or felony sexual assault. Others who are not entitled to bail include defendants with a parole hold or an immigration hold, or who are being held on an extradition warrant. I'll start with the bail process after arrest and booking and before the defendant's first appearance in court. Penal Code Section 1269B provides that the person who is holding the defendant in custody, that's typically the sheriff who operates the jail, but in some counties it's a different agency, that person has authority to take the following actions without consulting with a judge: to accept bail in the amount set by the arrest warrant, if there is one, or in the amount set by the bail schedule. And I'll describe the bail schedule in just a moment. Then to release a defendant who provides cash bail or a bail bond in the scheduled amount, and to set the time and place for the defendant to appear in court for his or her first appearance, usually called arraignment. Now, about the bail schedule. The Penal Code requires the Superior Court judges in each county to adopt every year a uniform countywide schedule of bail for all bailable felony offenses and for all misdemeanors and infractions except for vehicle code violations. Since each Superior Court adopts its own bail schedule, there are 58 separate felony bail schedules and 58 separate misdemeanor bail schedules in California. And as you can imagine, there can be wide variation in the amount of bail set for a particular offense in those schedules. In the materials is a 2-page extract from Alameda County Superior Court's current felony bail schedule, and it gives some idea of typical bail amounts. The bail schedule contains a list of statutory offenses and a presumptive bail amount for each offense based on the seriousness of the offense, and an additional amount for each enhancing factor. This is the schedule that the jailer uses to confirm the amount of bail the defendant must post in order to be released from custody before the first appearance in court. There is an opportunity for up to 8 hours before the defendant is released for a law enforcement officer to request that a magistrate, that is an on-call judge, increase the amount of bail above the scheduled amount if that officer has reasonable cause to believe that bail is not high enough to assure the defendant's appearance in court or protection of a domestic violence victim or a family member of the victim. The defendant can also make a request to the on-call magistrate to lower the bail amount below the bail schedule or to release the defendant on his or her own recognizance. But what happens if the defendant can't afford the bail amount? You can see that for a felony offense, bail is typically many thousands of dollars. A defendant without sufficient money to post bail can contract with a bail agent to post a bond for the full bail amount. Bail agents charge a non-refundable fee. That is, even if the charges are subsequently dropped, the defendant will not get the fee back from the bail agent. Previously, the typical bail fee was 10% of the bail amount, but we've heard recently that here in Alameda County, the going rate is 6%. What that means is for a $10,000 bail, the defendant would need to come up with $600 for the bail bond fee. The bond is a financial guarantee by the bail agent to the court that the defendant will appear for all required hearings. The bail agent does not provide any cash to the court. It's a promise to pay the full amount if the defendant fails to appear. In addition to the bail fee, bail agents typically reduce their risk of loss by securing the bonds with collateral, which often is property from the defendant or from his or her family and friends. If the defendant is unable to post bail or afford a bail bond, the defendant will remain in custody until arraignment. That is the first appearance in court. A defendant must be arraigned within 48 hours of arrest, excluding Sundays and holidays. At arraignment, the court will review the bail amount, that was set either by the arrest warrant, the bail schedule, or the on-call magistrate, and may adjust it higher or lower depending on the circumstances. Before 2008, in setting bail, the court was required to consider the seriousness of the charged offense, the prior criminal record of the defendant, and the probability of the defendant appearing in court for hearings and at trial. Then, in 2008, the Victims' Bill of Rights, more commonly known as Marsy's Law, amended the California Constitution to require that the safety of the public and the victim must be the primary considerations in determining the proper amount of bail, together with the safety of the victim's family. My time is up, so I will stop there.
Thank you. I want to thank you for having me and to thank you for taking on this important subject. It gets very little attention or not enough attention from policymakers or academics, but it's crucial for so many reasons. It can really have profound effects on people's lives and on the functioning of the criminal justice system. Bail and pretrial is really the widest part of the funnel, and if we want to take on mass incarceration, this is where we should start. So the majority of people in California jails are unsentenced. 90% of people detained pretrial are there because they cannot make bail. And detaining so many of the presumptively innocent is not a wise use of jail beds, which are a scarce and expensive resource, but it also has other harmful effects. Even a short time in jail increases the risk of criminal activity pretrial. Longer pretrial stints are associated with loss of employment and housing, and even those people who do bail out suffer from having to make such a large financial outlay because money spent on bail is not money that is available for food, clothing, and other necessities. More than that, though, money bail is an ineffective way to promote public safety. The amount of money someone has bears no relation to the risk they pose. And even if money bail did make sense in theory, it does not make sense the way we practice it in California. Any putative gains from financial terms of release are vastly outweighed by the costs of keeping poor people in jail. My ultimate position is that we should shift away from money bail, particularly commercial surety bail, which means the bail bond industry, and towards pretrial services and risk assessments to make our decisions about pretrial populations, with the caveat that risk assessment tools be non-proprietary and completely open, and that we make sure that they do not have disparate impacts on the basis of demographics unrelated to public safety. So let me start with the big picture. The goal of pretrial is to make sure we let the right people out and keep the right people in. We want people who will show up in court and stay out of trouble to be let out, and we want people who can't do either of those things to stay in, and our system should be able to sort the two in a reliable and accurate way. But I want to make an initial point. We can't just conclude that keeping everyone in custody is better, and sometimes that's the inclination in the research and discussions I've had with criminal justice practitioners, that you should lock people up to be on the safe side. But there are many costs to over-detention. First, people in jail awaiting trial are presumed innocent, and if they can't get out, their lives are irrevocably damaged. In Santa Clara County, which I and my students studied, the median time served pretrial for misdemeanors was more than a month. These are low-level crimes, and if you're in jail for more than a month, you lose your job and probably your housing, which makes it very difficult to rejoin society and avoid criminal behavior. It costs money to have people in jail, about $200 a day in Santa Clara County, and we don't have a lot of beds, particularly after realignment. Crowding makes programming and administration difficult. Crowding also makes jails less safe for guards and inmates. And when people are in jail, the system suffers. It's difficult to develop the defense case. We want to make sure we find people guilty of what they did, but only of what they did. When you're in jail, the pressure to plead out to time served in order to go home, no matter what the facts are, is a very heavy thumb on the scale. You can ask yourself, would you rather stay in jail and fight a charge or leave today? Most people would rather rejoin their lives than fight even a flimsy case. So if these are our goals of pretrial, we have to analyze whether money bail does a good job at advancing them. And as Eve pointed out, bail is not a synonym for bail bond, even though many people use it that way. Legally speaking, bail itself just means release before trial, and it also includes release on own recognizance, or OR, and supervised OR. But even the kinds of money bail are different, and our system really encourages commercial surety bail or bail bonds. So if you want to post cash bail yourself, you have to have cash or a cashier's check for the full amount. Some counties allow you to use credit cards, but you pay it with the court, and if you fail to appear, you lose it. But even if you do appear, sometimes it can take a while for you to get your money back. With bail bond, you only pay 10% of the bail amount. You don't give it to the court, though. You give it to a private company, and that company just makes a promise to the court, so no money is given to the court. That 10% is non-refundable, as Eve pointed out, and is only good for 12 months. So if your case goes on longer than that, you pay another 10%. You only get your money back with cash bail. You do not get your money back with bail bonds. So there's no real, so that's the carrot is really only with cash bail. Now, with a bail bond, if the defendant fails to appear, the bail bond company still doesn't pay the court automatically. It automatically gets 180 days to find the defendant, and it can even extend it another 180 days with good cause. So to summarize, bail bonds mean a defendant pays less and the court gets nothing until the defendant has absconded for at least 180 days. But cash bail means the defendant pays the full amount and loses it the moment he fails to appear. That doesn't make sense to me. I mentioned OR, or own recognizance. There's typically no information about OR in the holding cell in jail. People pay to bail out sometimes even when they're eligible to be released without payment. Meanwhile, there's usually information about bail bonds in the form of advertisements the jail sells via the jail advertising network. In Alameda County, both the Santa Rita Jail and the Glen Dyer Detention Center have ads that are paid for by the bail bond companies. In Santa Clara, the county made $100,000 a year from bail ads, but it decided to revisit this decision because $100,000 is really peanuts compared to the $15 to $20 million in premiums bail bond companies earned each year in Santa Clara County alone. My main problem with bail bonds, though, is the focus on failure to appear, or FTA. Most bail bond proponents will talk about FTA as though it were all that matters. But failure to appear is not a synonym for public safety. Public safety has to include what you did when you were out on pretrial. I care more if you were out committing crimes than if you didn't show up to court, and I also know that if you didn't show up, it might be because you forgot, or you were worried about missing work, or had no transportation. If you got arrested, it's because you were doing something criminal, and that's what I mean when I talk about public safety. But ironically, there is no penalty for a bail bond company if the person they bailed out gets rearrested. In fact, it might be good for them. You get another potential bail bond contract and another 10% premium, or at worst, you get a guarantee that the defendant will show up in court because they're already in jail. A federal survey shows similar national rearrest rates for OR and bail bonds, but this includes all forms of OR, including those with no pretrial services. With pretrial services in California, however, the differences are dramatic. A 2011 study commissioned by Santa Clara County looked at outcomes from OR, supervised OR, and bail bonds. Almost 3 in 10 people were rearrested when released on bail, which is almost 10 times the rearrest rate for OR and supervised OR. Despite all this, even when commercial bail fails, it doesn't automatically bear the cost. Bail that should be forfeited from failure to appear is typically not. The default rule in California is that forfeited commercial bail is exonerated unless the state serves notice, and there is a declaration in open court that bail is forfeited. If bail is forfeited, it is either collected in full from the defendant or his or her family, or it is collected from reinsurance that bail bond companies purchase. The downside risk is extremely low, even if we were to enforce and collect forfeited bail. So bail bonds are a very good business. You collect now, you pay later, if ever, and even if you pay, someone will reimburse you. Ultimately, even if we were to administer commercial bail more effectively, collecting on forfeited bail and regulating it, I don't think the system is worth saving, although that might require a constitutional amendment to Article 1, Section 12. I note that the California Code of Regulations says the floor on bail bonds is supposed to be 8%, so I'm very surprised that it's 6% in Alameda County, although the other part of me is not surprised based on what I've learned from Santa Clara County. So ultimately, I don't think people with more money pose less of a threat to public safety than poor people do. I'm more than happy to elaborate on any of these issues. And I want to say one last thing. Even though I gave my examples from Santa Clara County, I think that Santa Clara County is really to be commended. They worked very closely with me and my students. The Santa Clara County Bail and Pretrial Release Working Group collected lots of data. And I don't want to disparage them for actually collecting data and releasing facts. I actually think that better collection and dissemination of data is long overdue, not only with bail, but with so many other issues of criminal justice. I think if we had more information, it would make future problems easier to diagnose and future policies easier to access. So that's one thing I think that we could all probably agree is very low-hanging fruit. Thanks, and I'll look forward to your questions and comments.
Thank you to Professor Ball and Ms. Hirschkoff. Just a quick acknowledgement. Besides Brandon from Assemblymember Thurman's office, I also wanted to recognize Andrew Lamar from Senator Bob Hertzberg's office, who's here. And Senator Hertzberg has also been a leader in looking at our money bail system and seeking better paths forward. So thank you for your presence and for your leadership. Next, we have our second panel, which will address the human and economic cost of money bail. We have 5 panelists, starting with Zachary Norris, Executive Director, Ella Baker Center for Human Rights, then Jessica Bartholow, Policy Advocate, Western Center on Law and Poverty. After that, we'll go to Margaret Dooley-Sammuli, Criminal Justice and Drug Policy Director at the ACLU. Melody Henderson will provide some personal testimony regarding her own experiences. She's from San Diego. And then John Jones III, Communities United for Restorative Youth Justice. Thank you to all our panelists for being here. And Zachary, why don't you kick us off?
Thank you, Assemblymember Bonta and Senator Hancock, for your leadership on this issue. I was really excited to be here, so excited that I went to the wrong address initially. So apologies about that, but I was late for the first panel, but it appears I'm on time for my panel, so I'm doing all right. I am really excited to be here because it's the day after the 4th of July, and in this country, one of the things that we are pledging to be about and to value is that people are innocent until they're proven guilty. But if you can lose your home, if you can lose your car, if you can lose your job without ever being convicted of anything, that's punishment. And it is, for us, part of a larger punishment economy that disproportionately impacts low-income communities and communities of color. I'm the executive director of the Ella Baker Center for Human Rights. Ella Baker believed in the power of ordinary people to make change, and we push for a truth and reinvestment agenda, which is the nation reckoning with a long history of racial injustice and gender-based violence that shows up particularly acutely in the criminal justice system, and reinvestment back into communities in the form of books not bars, jobs not jails, housing not handcuffs. We believe that we should stop locking up innocent people. California in this regard is actually worse than the rest of the country if you look at our bail statistics. And right here in Alameda County, nearly 4 out of 5 people in Santa Rita jail are being held pre-trial. The majority of people are detained pre-trial because they can't afford bail. And as I've talked about, this is part of a larger punishment economy. We worked with Forward Together, the Research Action Design Collective, and 20 community-based organizations across the country to produce a report called Who Pays? The True Cost of Incarceration on Families. In that report, we found that 2 out of 3 families, when they have a loved one inside the justice system, face the difficult choice between paying for basic necessities like food and supporting their loved ones in the system. 1 out of 5 families lost housing due to incarceration and the cost of having a loved one in the justice system. All of that starts with our pretrial policies. We know that families supporting loved ones who are arrested are forced to make those difficult choices, partly because families typically can't pay the 10% required up front, so they end up on payment plans, pushing them further into debt. If the charges get dropped later, the families are still on the hook for the fee. When people remain in jail because they can't afford to pay bail, the family is further impacted. As I've talked about, other family members have been forced to drop out of school or their jobs to take on responsibilities due to their family member being detained or incarcerated. Money bail disproportionately impacts communities of color, Black and brown folks, who are overrepresented already in arrest and in incarceration. And statistics show that black people are less likely to be released on their own recognizance. Black people ages 18 to 29 get significantly higher bail amounts than all other groups. And if bail is set primarily based on the seriousness of the offense, it also often discriminates against low-income people of color, resulting in higher rates of conviction and incarceration. So what I want to suggest is that we need a whole new paradigm when assessing who should be detained and who should be let go, that we actually need to look at needs assessment rather than risk assessment. Doing away with bail is ineffective and it punishes poor people of color, but we've seen in the past that sometimes the next fix isn't always the exact right fix. And so one of the things that we have to be very much aware of, and it came out in a ProPublica article that folks may have seen recently that talked about some of the risks of using risk assessment only, is that it can replicate some of the same racial disparities that we see in other aspects of the system. So we believe that the question should really be about, what do you need in order to make it back to court? Studies show in the juvenile justice system that if you give young people a phone call at an appropriate time and say your court date is going to be at this time, it drastically reduces people missing their court dates. Do you need bus fare to get to your court date, for example? I find it both problematic and indicative that there are this presumption of guilt rather than innocence once someone is charged with a crime. It's in all of our interest from a public safety standpoint to make sure that people have the supports they need to show up for court. And it's in all of our interest to make sure that people are not away from the things that actually keep communities safe, that they are not away from their children, that they are not away from their employment, that they are not in a position where they're likely to lose their housing or to lose their car because they don't have a driveway and have to move their car. All of those things, when people lose those basic fundaments, basic critical pieces of what actually makes community safe, when people are going to their jobs, when people are coming home to their children, when people are taking care of their responsibilities, that is what makes us safe. Not the safest communities are not the communities with the most police and prisons. The safest communities are not the communities where people are basically funneled into the system, but rather where people are supported to do the things that all of us want to do, which is take care of our families and take care of our loved ones. So thank you.
Thank you. Again, my name is Jessica Bartholow. I'm a policy advocate with the Western Center on Law and Poverty. I want to take the moment first to thank the chairperson and Senator Hancock, both who have been leaders in the Capitol and are profoundly important in providing space in Sacramento to discuss the status of boys and men of color and of people living in poverty. So thank you for all that you do in your body of work. You've heard today about the bail system, and I don't need to reiterate how unjust it is that a person who is arrested but has not been convicted, so presumably to be innocent, presumed to be innocent, it remains in jail under lock and key because they cannot afford to pay bail, simply because they cannot afford to pay it. According to the Prison Policy Initiative, the majority of people who are in jail because they can't afford to pay bail are at the very bottom tiers of our economic ladder. My experience at Western Center and as having a lived life in the first half of my life in poverty has brought me to too many occasions of reviewing policy, working to change it, policy that is unfair and unjust, and is established in ways that minimizes the life, the bodies, the humanity, the property, the families of people simply because they're poor. Our current bail system is the epitome of that type of policy. I've been asked today to come and share some of the stories that we see at the Western Center on Law and Poverty as one of the legal services support centers. And for people who are unfamiliar with legal services, it should be noted that we cannot provide criminal representation. We cannot represent somebody in law because of a criminal case. So the cases that we see are come to us because people have become homeless, because they've been evicted. They come to our eviction clinics, or through our public benefits clinics, or through our access to jobs and justice work. So it was brought up, of course, this should be obvious, but to spell out a little bit more about what happens when somebody is held in jail because they cannot afford to pay bail. One of the first things that happens is their income falls to zero. Whether it's earned income because they're unable to work and therefore they lose their job, not just for that day, but usually for the remainder. They will lose their job. They don't get it back. The types of jobs that low-income people have are not the types of jobs that you can take an absence from and return to. They also lose their income because they lose their public benefits. Many people who are low-income, even if they're working, rely on public benefits to help pay their basic needs, their rent, their food, their clothing. If you are on public benefits and you're in jail for more than a month, if you're expected to be there the following month, you are completely pushed off of your public benefits. For some people, elderly and disabled people, they can come back. It's a period of time of 12 months that they have to come back, but they have to begin the process of reapplying. That means that once they are let out of jail, they will have several weeks, if not months, sometimes years, to regain the public benefits and to become stabilized in their housing again. They're unable to pay rent, and we heard about that. Dr. Ball talked about unable to pay rent. What that means is they are evicted. They are evicted, and usually people that they live with, their children, their parents, their significant other, are evicted too. This is because the income they had was part of making a very unstable housing situation work. And without that little piece that they might have brought to the table to help pay the rent, the family's evicted. If they lived alone, they were evicted and their things were discarded and not to be found again. We had a client whose things were put on the back in the backyard, and it rained on them. Their family photos, the little things that they had. It might not be much, and for people in middle-class America or wealthy Americans might look at the things that a low-income person has and think it's not that much worth to have, but they're all that people have when they're in jail because they couldn't afford bail. People's cars are towed. We take for granted if you live in middle-class America or wealthy America that you have a place to park your car that's not time-limited, but low-income people often don't. If their car is parked on the street or in a place where they can't maintain their car for even a day or two, their car is towed. When their car is towed, they have to pay a fee. Even if they can afford to get the car out, they still have to pay the cost of the storage of that car, and oftentimes they can do neither, and they go further into debt. Their family suffers, and you heard some about what happens here, but in particular, we see parents whose children go into foster care. If they're a custodial parent, they can face charges related to that too, and many have a hard time getting those children back. If they're not a custodial parent, they have child support that they pay. Without earnings, that does not necessarily mean that they don't have to pay. It should, and we would like it to, and they have the right to request a waiver from the payment, but it is not automatic. While being kicked off their benefits is automatic, while having their car towed is automatic, while getting a failure to appear, additional citation or bail violation is automatic, their payments to foster care or to their child support is not, and those bills rack up. And their government debt, they cannot be discharged in bankruptcy, and they have high interest rates. So in closing, I just want to invite us all to think about what is public safety. You heard my colleague from the Ella Baker Center frame it so well. What is public safety? If we know from the experience of other states that having a money bail doesn't actually increase the likelihood that somebody will return, but instead having support systems to help people return for their court date, instead doing those things has a better outcome than money bail, then why aren't we pursuing those? And when we talk about public safety, why are we not thinking about the children left behind? Why are we not talking about the elderly people that the people in jail may be caretaking, or the communities and the families that will go deep into debt? One thing that we do know increases the likelihood of recidivism is poverty, inability to work, inability to find housing. Being homeless alone will make you a criminal when we have laws that prevent people from sleeping, resting, or even owning a tent. We are very eager to be part of this conversation. We are not experts on bail. We are experts on poverty. And it's clear to see that this policy has been made in our state and our country without consideration of people who are living it. And we thank you for having us today and look forward to the conversation.
Thank you. Good morning. I'd like to add my thanks to the chair and the Senator Hancock and others who are here for taking time to address such a critical issue and giving us this opportunity to talk about it. For nearly 100 years, the American Civil Liberties Union has been our nation's guardian of liberty, working in courts, legislatures, and communities to defend and preserve the individual rights and liberties that the Constitution and the laws of the United States guarantee everyone in this country. Yesterday, we celebrated Independence Day. On that day, we celebrate liberty as a fundamental American value. Yet today, we're here examining a system that has fundamentally failed to protect this right. Thousands of Californians who have been arrested, accused, but not convicted, are behind bars in our unhealthy, overcrowded, dangerous, and sometimes deadly jails. Based on accusations or suspicions, their lives and the lives of their families, as we've heard, are interrupted in sometimes unrecoverable ways. As of last year, the most recent data that we have statewide, over 60% of the California jail population, or about 45,000 people, were not sentenced. Some of them, including some innocent people, are there simply because they cannot afford the high cost of bail. Meanwhile, on the other side of things, wealthy defendants, including some who do pose a safety or flight risk, are able to put their houses up as collateral or even just write a check and walk free until their court date. California's cash bail system is all about money. It rewards the haves and punishes the have-nots, regardless of innocence, fails to adequately assess whether a person should be released, defaulting instead to keeping people in jail through high bail amounts, and costs millions in taxpayer dollars each year in unnecessary jail costs, while insurance company-backed bail bonds agents rake in millions. In Stack v. Boyle, the Supreme Court held that the traditional right to freedom before conviction permits the unhampered preparation of a defense and serves to prevent the infliction of punishment prior to conviction. Unless this right is preserved, the presumption of innocence, secured only after centuries of struggle, would lose its meaning. Chief Justice Rehnquist wrote, 40 years later, "Liberty is the norm, and detention prior to trial is the carefully limited exception." Or it should be. That detention before trial has become more the norm demands our urgent and immediate attention. That much of this detention results not from an informed determination that detention is actually necessary, but rather on the content of one's bank account or family wealth, is unconscionable. This inherent injustice in the money bail system has a more serious impact on people of color than on whites because of racial bias at every step of the system, from policing tactics to courtroom decisions, and bias likely leads to higher bail amounts for people of color than their white counterparts arrested and suspected of similar offenses. And again, we cannot presume that ending the money bail system will eliminate racial injustice in the system. We have to be very careful of the changes that we're making to take that into account very deliberately and intentionally. This system does not respect defendants' due process, nor does it protect crime survivors or the public at large. because wealth becomes the primary criteria that determines whether a person is released. Have enough money, you secure your release. Don't have enough, you can't secure your release. How much is enough? In California, the median bail amount is $50,000, compared to $10,000 average nationwide. But as others have pointed out, even if someone's bail amount is substantially lower, for some, $20 in bail is as hard to come by as $50,000. We can do better. Allowing more defendants to return home while awaiting court hearings will reduce our jail population and save California millions of dollars. We can use data and technology to help judges determine whether a person should be released and what conditions of release might be necessary. We can and must return to a system that takes our American values seriously, that all people, regardless of wealth or skin color, deserve equal protection under the law. Thank you.
Hi, good morning. My name is Melody, and I'd like to talk to you today about my own personal experience with the bail system and the impact it's had on my life for years. A little over 9 years ago, I did something really stupid, and I was charged with a low-level felony. I ended up surrendering myself to Las Colinas Detention Facility in San Diego, and my bail was set at $50,000. So at the time I was 21, I was a college student living paycheck to paycheck, so there's really no way that I could afford the bail. I had to make the decision to either agree to a debt that I knew I couldn't afford or to sit in jail for the remainder of the trial. Going to jail, I mean, you can only imagine, but once I was there, it was nothing less than a nightmare for me. My grandparents, who are my adopted parents, also on a fixed income, had to come up with the money for a down payment on my behalf because my job was then at risk. So the day I was released, I met with a bail bondsman to sign a contract to set up a payment plan. And pretty much the only difference between myself and being out free and the other women that were still in jail was the money that my grandparents let me borrow. So after a year-long process of court proceedings and no money for a good lawyer due to high bail payments, I was sentenced to 3 years probation, community service hours, restitution in the amount of $431, and court fines, which ended up being lowered due to low-income programs that the court offered. However, the bail companies didn't have these low-income programs, so the payments were set pretty high. After completing all the terms of my probation and paying my debt to society, I was still struggling to pay my debt to the bail bonds companies. It was still years after that I finally finished paying those loans to the companies, and I had to put college on hold. So I was able to work enough hours to afford my bonds payments on top of my other payments. So eventually my other bills ended up going to collections. My bail payments had become my priority at the time. So now on top of my criminal record, I was now 24 years old with severely damaged credit. I was borrowing more money on top of my bills month to month to make those payments. So just the stress I was under, I would often become depressed, and sometimes I just couldn't see the light at the end of the tunnel. However, over the past 10 years, I've started my own business. I've helped raise my sister and now my mother to my 6-year-old son. Thankfully, I had the support of my family to assist me with getting my life back together, but many others aren't as lucky. Thank you for the opportunity to tell my story today.
Good morning, everybody. My name is John Jones III, and I'm the life coach with Courage, Communities United for Restorative Youth Justice. And as I'm listening to the panelists and listening to Melanie's story, I can't help but just reflect on this idea in my mind that injustice exists because someone makes $1 from it. And I'm so humble and grateful, and I appreciate Assemblymember Rob Bonta, as well as Senator Hancock and all the other elected officials or the staff who are here, because history teaches us that it was elected officials who legalized institutions like slavery. It was politicians who made it legal for a man to beat his wife. So that means the reverse can be true as well. It can take elected officials to change some of these evil systems that exist today that truly dehumanize people. And as I mentioned, slavery, sometimes we forget. We think of that as just a purely physical institution, but it was a financial one. And it was one that didn't just enslave Africans or African Americans. The first slaves were poor Europeans, as well as the indigenous folks here. So there are lots of groups of people who are impacted by what we're talking about today, bail. When I was in the great city and county of San Francisco, Christmas Eve, 1999, I was there at a bar. And I came out this bar and I was going to my car. And at the time, my best friend had the keys to my car because I was drinking. But as we were walking to my car, there was an officer who shined his light into my vehicle. And I don't know about you, but if you see someone shining a light in your vehicle, you want to know, like, what's going on here, right? What's the problem? And he said he's seen drugs in my car. I'm like, wow, you got x-ray vision. You shouldn't be a cop. Maybe you should be something else. But if you seen somebody in my car, you should have arrested him, right? He said, let me search it. So I'm like, no, I'm not going to search my car. That don't even sound right. But my buddy gave him my keys. Long story short, this officer said he found some drugs in my car. So here I'm arrested, my first arrest as an adult. And I'm thinking, I'm expecting to get OR'd. Didn't happen. So now here it is. This is December 24th, 1999. So December 29th comes, and I don't know if you folks remember, because y'all probably freaked out right now about this Zika virus, but who remember Y2K? And I'm like, no, I am not staying in this county jail because 2K come and they might have me in here for 18 murders. I got to get out. Let me bail out, right? So my bail was set at $15,000. So with the 10%, that's $1,500. So I paid my bail and I got out. So I returned. I lived in Oakland at the time, still do. I went back to the city to try to retrieve my vehicle, which was impounded. And I go down there and they say, we have no record of your vehicle being impounded. I said, that's bizarre because I was arrested because they alleged that there was some drugs in my vehicle. So I'm like, okay, so I'm walking back toward the bar station and the same officer who arrested me see me. He ran a red light and pulled up on me and said, hey, what are you doing out? What do you mean what I'm doing out? I made bail. No, you're not supposed to be out. Proceeded to search me for 40 minutes. Eventually, he said he found some drugs in my pocket. So I was arrested again, given a new bail. The new bail was $35,000, which 10% is $3,500. I didn't have that money. Come to find out, they have an expert who's, they tested the drug and found out the drug was fake. It was some wax. So my lawyer asked, well, since this is wax, and last time we checked, it's not illegal to possess wax, if that's what he had, can we reinstate his bail? The judge said, well, we want the original judge who placed the bail to make that consideration. So this is a Friday. So Monday came around, and guess what? They refiled on me. I was charged again, and this time they came with a different drug. So I'm saying this for a reason, because when we talk about bail, it's larger than just bail itself. It's how bail can be used in a punitive way. It can be used to threaten you. I want to give you another example real quick, and I'm watching you, timekeeper. So watch me, because I get going. So we're good. It's all right. I won't be offended. When I was in Oakland in 2003, I was arrested, long story short, for assault. So I bailed out immediately. My bail was $15,000. I paid $1,500. I got out. When I went to court, the prosecutor was like, Your Honor, why is this guy out? He should not be out. He has a violent past. The judge said, well, he made bail. Nothing I can do about that. Well, you should raise his bail. So the next time I go to court, the public defender I had, for some strange reason, decided that he didn't want to represent me anymore. So he went and met with the judge before I had a chance to. So when I entered the courtroom, he seen me and his eyes was this big. He said, oh, well, I can't handle your case anymore, but let me try to bring you up in front of the judge. So the judge said, Mr. Jones, can you stand on this side? So for those of you who are blessed enough to not be in that position, when they ask you to stand somewhere, that means you're going to get handcuffed. So I'm like, what's going on? Why I got to stand over here? He said, well, you were late for court this morning, so we're going to revoke your bail and put you in custody. Now, mind you, I'm working at this time. I'm making like $10.50 an hour. This was on a Wednesday. They put me back into custody, raised my bail to $50,000. I had to wait a couple of days to get a bail reduction hearing. They lowered it $25,000, which is $2,500. So I already paid the $1,500. Now they want me to pay an additional $2,500. So ultimately, I paid $4,000 plus fines and fees for an arrest that ultimately led to a misdemeanor conviction. This is an idea that's showing you that this is about money. Just like slavery is about money, incarceration today is about money, bail is about money. And this is something that we cannot stand by, because if we're really serious about public safety, it only takes 2 days, right, for a no call, no show. You can't call your job collect. You in jail 2 days, you lose your job. You lose your job, you lose your house. And I want to end with this. Think about that. You can lose your house. There is only one place in America that you are guaranteed a roof over your head, and that's in jail. So thank you.
Thank you. Next, we have our final panel on money bail and its impact on the criminal justice system. I'm pleased that we have with us Chuck Denton, Alameda County Office of the Public Defender, as well as George Gascon, San Francisco District Attorney. Let me turn it over to you.
Thank you very much. I want to thank you, Assemblyman Bonta and Senator Hancock, for shining a light on this issue and also putting together this terrific panel. I hope I'm not about just to spoil that. For most of the clients that I represent, the scheduled bail is the equivalent of no bail. The public defender represents only indigent clients. So in practical terms, that means that if you have more than about $2,100 and you're charged with a misdemeanor, we can't represent you. It's got to be under $2,100. For a felony, under $3,000. Most of the clients are well below those limits. In fact, 90% of the people we interview qualify for our services. And most of those people are well under the limit. So most of the people that we represent are making less than, say, $25,000 a year. So if you need kind of a yardstick, the federal poverty line is $20,000 a year. And that doesn't take into account the cost of living in Alameda County. I saw a study which suggested that for a family of three, minimal housing costs, food, transportation, and childcare, they need $67,000 a year. So most of our clients don't have much cash on hand or liquid assets. And the bail is typically set well beyond their means. Now, the idea of the bail schedule is to promote uniformity among the judges, but at least from our perspective, it often seems like it's also designed to leverage defendants into plea bargains. So let me just, if I can give you an example, let's imagine a fellow works at PetSmart, and there's an abandoned car in his neighborhood, and he and his buddies get in the car to hotbox, smoke marijuana, and he's sitting in the driver's seat. The police see the smoke or smell the odor. They stop him to give him a citation for the marijuana. They find out the car is stolen. So he's arrested. He's taken into jail, and he forgets, because he's high, that he's got another sack of marijuana in his sock. So he's also charged with bringing drugs into the jail. So he's now charged, comes to court the following day, and typically in the first court appearance, there's no defense attorney there to represent him, although that has changed recently. And so he's charged with car theft and bringing drugs into the jail. That's $25,000 bail apiece. And many times they'll be charged in the alternative, so he might also be charged with possession of a stolen car or grand theft. Without a lawyer there to say, well, those are the same charges, those shouldn't be added on, his bail could easily be another $40,000 for $90,000. Now, I didn't, 6% bail, that's news to me. Maybe that's because none of my clients can make bail. But even still, that's $3,000 or $5,000 to the bail bondsman. That's money you'll never get back. And, you know, if you're working at PetSmart, you can't afford that. So what's the impact that has? Well, the first is it's going to really hamper this fellow's ability to defend his case. Let's imagine we find out that the car was stolen the week before on a Tuesday. Well, the client was playing basketball with his buddies at the park that day. But if he's in custody and he doesn't know the last names, the telephone numbers, and addresses of all the guys he plays basketball with in the park, and I've been playing basketball with the same guys for the last 30 years, and I couldn't tell you one of their addresses, we're not going to be able to find that person. If he's out of custody, he can dig those folks up, and we can put together an alibi defense, but not if he's in custody. If he's in custody, what will happen is that when he finally gets to a pretrial, he'll be made an offer, and oftentimes the offers are of the kind that Melody described. If you take probation, you can get out of custody. So the client is faced with the Hobson's choice of pleading guilty to something that he didn't do in order to get out of custody, in order to save his job, in order to save his apartment, so that his kids aren't taken away. That's a choice that many people make. And it's not just that, it takes a variety of forms as well. The person may be guilty of, in this case, he's guilty of bringing drugs into the jail. If he's out of custody and we can put together a mitigation package, show that he's working and other things, maybe that's the charge that we ultimately settle on a plea deal with. But if he's in custody, he's apt to take the first deal that's offered, and that's often the worst one. The other thing that happens is that very often we have clients who agree to probation conditions that they can't possibly satisfy. My favorite is the homeless person who agrees to a curfew. So all of these things, I think, end up having a corrupting influence on the criminal justice system. Now, not everybody who gets arrested is not guilty of the charges or not guilty of some of the charges, but many of the people are less guilty than it would appear at first blush. But many of those people end up taking a deal in an effort to get out or shorten their sentence that ends up having serious consequences down the road. One of which is, this gentleman, if he ends up on felony probation, the next time he gets arrested for anything, he is going to be held no bail on a felony probation warrant. So for the next 5 years, every time he gets arrested, he will be held no bail because he's on felony probation. And in Alameda County, people who get arrested on probation holds are held without bail. Now, I don't want to just be the messenger of bad news. There are some good things that are happening. For example, my office received a grant. For the last 3 months, we have been staffing an arraignment court, the very first appearance. And we have, during that 3-month period, we have secured the release of 359 clients. Now, some of these people would have gotten released a day or 2 or 3 days later, but that day or 2 or 3 days later can make a big difference, as John Jones was just talking about. That can mean the difference between saving your job and losing it. Our court has also tried to develop some early intervention courts. So we have a behavioral health court that people who have mental illness can be diverted to. We have a veterans court for veterans. There also is the opportunity, and I think now a greater awareness of putting conditions on bail so that we start to deal with the root problems very early on. So the client who has a drug problem can be released on the condition that he get treatment, that he tests, that the mentally ill client can be released on the condition that he seek treatment as well. These are all things that we can do, and things like Proposition 47, I think, are also things that can help to solve this seemingly intractable problem. Thank you very much.
Thank you, and good morning, everyone, and thank you, Assemblyman Bonta and Senator Hancock, for putting this together. I'd like to kind of take a different tack now, and you know, we've talked about the problems with the money bail system, which are many, but also there are solutions to this, and it's really going into what we call a risk-based release. When we base our release, instead of using money, we use risk. We actually enhance public safety. Not only do we contribute to the notion of justice, but we actually are enhancing public safety. And just as importantly for many, a data-driven pretrial risk assessment actually saves money, which for many is very important as well. Money bail, plain and simple, is a social justice issue, but it's also a public safety issue. When we talk about releasing people based on money, we are really ignoring the risk that that person presents or does not present to public safety. So we have people that maybe actually be very risky, but they can afford to bail out, and therefore they do bail out. And we have people that are not risky, but they remain in custody because they're unable to post bail. That does not necessarily enhance public safety. In fact, I would argue that it does the contrary, and I can tell you many cases in my own jurisdiction where people that we believe that are a risk to public safety get released, while many others that are not remain in custody. Money bail is a problem in many different ways. We have talked about the social justice issue, and I know that there are many speakers here that have talked about it, but it also clogs the criminal justice system. When you have people that are being held in custody because they cannot afford to bail, that space that is being occupied by someone that is not a risk to public safety may not be available to someone that is actually riskier and should be occupying that space. We know that actually moving away from money bail works. There are many jurisdictions already that have moved away from money bail and are doing very well. In fact, there are 29 jurisdictions. In San Francisco just recently began the process of moving away from money bail. I've been working for 3 years with the Arnold Foundation, and we started a pilot program where we're beginning to use a risk assessment tool to release people that may not necessarily be able to afford bail, but they're not risky and they should be released. We do have some problems, though. The California Constitution actually guarantees money bail, and as I mentioned earlier, there are people actually that should not be released from custody because they're dangerous, but they can afford to bail out, while the reverse is also true for people that cannot afford to bail out. So in order for us to really fix the system, we have to think very globally, and while jurisdictions like San Francisco, by going to a risk assessment tool, is beginning the journey of fixing the problem, and certainly in Alameda County with the public defender doing what they're doing, is also working towards a solution. The reality is that we will have to go and fix the California Constitution if we really want to move away from a risk assessment, if we want to move away from a money bail system completely and move into a risk assessment environment, which I believe is what we need to go.
Wonderful, thank you. Can we have a round of applause for our panelists? Thank you again to all of our panelists for your wisdom and your input, and all of the persuasive points that you've made about our money bail system. I also want to thank you for being right on time. So we've been doing great with our time. We have our full 45 minutes available for public comment. So this is the time when I'd like to invite folks up who would like to make public comment. We'll be doing it to my right, your left, right here at the podium. So why don't we can have a line along the wall, and I can invite folks to make public comment. I also want to recognize Andrea Perry from Assemblymember Quirk's office, who's here today. Thank you for your participation and for Assemblymember Quirk's leadership in many things, including many public safety issues. Thank you. If we're ready for our first member of the public to make public comment, let's do so.
Thank you, Assemblymember Bonta and Senator Hancock. Also want to thank my colleague Chuck Denton from the Public Defender's Office. My name is Kevin Dunleavy. I'm the Chief Assistant District Attorney in the Alameda County DA's office. I was invited to speak on a similar panel that was called by Supervisor Richard Vallier and Assemblymember Quirk back in February of this year. And I was joined on the dais by that day of another Assistant Public Defender, Brian Bloom. Eve Hirschkopf was on that, and I just want to say that for all the outstanding speakers, this is an issue that is of vital interest of everybody in the criminal justice system as the courts go through this important process of evaluating the public safety risk versus the individual liberty of those that are accused of a crime. I do want to say, however, that there are just some distinctions in California than there are in different states. And there are some protections that are here in California that do not exist in other places. In Kentucky, for example, or other states, it is just the police officer that does the charging. In the state of New York, in terms of speedy trial, felonies have to be brought within 6 months. However, if the delay was not the cause of the district attorney, if the delay was simply because there were overcrowding of courts, those time periods get extended. In California, and what we practice here in Alameda County, we rely on the discretion of the district attorney that when they bring charges, it's not just based on probable cause, that there's a weighing evaluation, that they look at the charges as they come in and make a decision that the prosecutor has proof beyond a reasonable doubt that they would be able to convince 12 jurors as to the proof of those charges. We also have speedy trial rights here, that a misdemeanor defendant has to be brought to trial within 30 days. If somebody's charged with a felony, that person has to be brought to a preliminary hearing within 10 days in which a judge, an independent magistrate, evaluates that evidence and would have a strong suspicion whether or not this person was guilty of the crime. In addition to the public safety considerations that are in the penal code, I think the members of the dais are correct, those that have pointed out that it is in the California Constitution, and any change would have to be in the Constitution, particularly the Victims' Bill of Rights, which was passed in 2008, Marcy's Law, that one of the considerations that has to be considered for release is the safety of the victim and the victim's families. So those things are all factors that need to be considered. I would just have to say, and I think Mr. Denton pointed out to some of the things that are going on in Alameda County, and particularly I would like to give praise to his boss, Brendan Woods, and my boss, District Attorney Nancy O'Malley, that with the courts, we have collaborated together to work on this issue. We started a project with the courts through a court grant to look at pretrial release. We currently use the Ohio Risk Assessment tool where we look at a series of number of questions. I know the last time that I spoke, I met before and afterwards with the Public Defender of Contra Costa County. I appreciate the words of the professor who talked about the collaboration, the beginning collaboration that's going on down at Santa Clara. Well, we will look at these different risk factors to make the determination if this person can be released on their own recognizance with certain conditions. In addition to some of the collaborative courts that Mr. Denton talked about, the other thing that we have started in Alameda County is an early intervention court, and not just for first-time felons that come through the system. We will take people in that court that have prior felony convictions so that long as they're not on current felony probation. But I will have to say, in Alameda County, with the discretion that is brought by the district attorney's office, one need look no further than other changes that have been made statewide. Prop 36 reform with regard to 3 strikes. When cases were being sent back, only 9 cases were sent back to Alameda County because the new offense was not a strike. We exercised that type of discretion. The last time that I spoke on this dais, that was February 19th of this past year, and we took a snapshot of our felony court, Department 112 in the Wiley Manual Courthouse across from the Oakland Police Department. We had 27 people that were in custody that day. I'm not going to go into the individual facts of those cases, but when you look at the issue of public safety, where we had 4 of those that were charged with strikes, we had 9 others that had strike felony convictions. There had to be, for the issuance of public safety, a bail schedule to be followed, and I would argue that that was followed. In contrast to that, I think with what we do with regard to misdemeanors in Alameda County, nothing's perfect, but I think it's pretty fair. We did a snapshot last year at this time as we got ready for this new project of pretrial release, and we did a 2-week period. It was actually this time period last year where we took the look at the last week of June and the first week of July, and we looked at the misdemeanors. At the first appearance of Department 107 in that same building, only 16% were in custody. But that changed by the time that there was a next court appearance with an opportunity for a bail hearing, with a good public defender's office making an opportunity to make a pitch about that person's custody status. And in preparation for today, if you look at the current jail population today in Santa Rita Jail, of the 2,450 people that are in, only 70 or 2% of the entire population are unsentenced misdemeanor defendants. So the work needs to continue to be done. I applaud the efforts that are made in San Francisco where they're looking at more of the risk assessment model. I want to assure both the Assembly member and the Senator that we are doing that in Alameda County. And for your review, I do have an overview of the bail process. And as Eve Hirschkopf had talked about, each year the Superior Court judges do have to put together a felony bail schedule and a misdemeanor bail schedule. I have the one from last year, the complete of both. So if I could leave this with the Assembly member. Thank you very much.
Thank you. Do we have any other public comment at this time? Please come forward. And anyone else who's interested, don't be shy. We want to hear your comments and your thoughts and your input, so please share them with us.
Thank you, Assembly Member and Senator. Thank you very much, and thank you, panel. My name's Jeff Stanley. I'm one of those awful bail bondsmen that we're talking about that makes a living by bailing people out of custody. The reason we have bail in our society is to protect society. Unless you're a victim of domestic violence, assault, theft, rape, drunk driver, or somebody under the influence of drugs, society needs this protection. And when somebody's admitted to bail, you know, I know there were some figures given earlier, but the Department of Justice Bureau of Statistics show that somebody that's admitted to surety bail, which is bail bonds, is less likely to commit a crime while out on bail than somebody released on pretrial or their own recognizance. People released on their own recognizance have a greater than 40% failure to appear rate, unlike bail, which is less than that. We need to protect society. And I know in light of Prop 47 and Prop 109, which we think, oh, well, we're going to take all these people out of the jails or the prisons. We're putting them back into the street. And in the last year, we've had a 10% increase in violent crimes. And the thing is, we're putting these people back into the neighborhoods. When somebody's out on bail, they have somebody who's responsible. Not only the bondsman, but a co-signer. So you have a family member, somebody who's looking after this person saying, hey, you got to make sure you make your court dates. You have to make sure you're doing what you're supposed to. You don't have that when somebody's released on their own recognizance. So I think there needs to be changes within the system, and our industry has even fought to lower bail amounts. I mean, it doesn't seem like it makes sense, but we believe that a lot of these bail amounts are too high. But there's a reason why. Is because these judges are seeing these people are not making it back to court, and they want to ensure that these people make it back to court. And as a society, we want to make sure that these people make it back to court. And thank you very much.
Thank you for your comments. Additional public comment, please.
Hi, my name is Corinne Rankin, and I'm, I guess, one of these god-awful bail bondsmen as well. A little bit about me. My father was born and raised in Oakland, California, and he started his bail bonds business in 1968 because he saw a need for it in his community. You know, I want to first point out something that's not being said here today about this pretrial program. When someone is released from jail on this taxpayer-funded pretrial program, you have to turn over all of your personal and private information to the government program, and your information is no longer private as it is with the bonds company. Your personal information will be shared, and you will be subject to weekly check-ins. In many cases, you will be forced to wear a GPS monitor around your ankle, and that GPS monitor is going to feed your whereabouts to the government program every second of every day. They will know where exactly you are. That doesn't sound like freedom to me. It sounds like a parole system that people are forced on before they're even accused of a crime. You know, I heard from some panelists earlier talking about, you know, wanting to completely do away with the surety bail system. So I just want to remind some of you that, you know, when Martin Luther King was arrested for promoting civil rights, it was a bail bondsman who bailed him out of jail. Do you think that if the decision were solely up to the government, that Dr. King would have been released from jail? When Oakland civil rights leader Huey Newton, Bobby Seale, and Eldred Cleaver were arrested, again, it was a bail bondsman who secured their release from jail. Do you again think that if it were up to this government program, that they would have allowed Huey Newton back on the streets? They probably would have labeled him a terrorist. My point is, lawmakers can't pass or create policy that conflicts with the Constitution. So I'm concerned about what's going on in San Francisco, not allowing people to access their constitutional right to surety bail. Now, if we're truly talking about the cost of bail, then I would argue that that argument would be for the judges who set the bail amounts every year. If there's a real concern about the financial burden to low-income families of color, then create a program to help them afford their civil liberties. If you indeed freedom as an inherent right, then create some sort of voucher system that will allow low-income people to access surety bail in the exact same fashion that people with money access it. Just because an individual cannot afford to access their right to surety bail, as outlined in the Constitution, doesn't mean that you should take that right away. Thank you.
Thank you. Next member of the public.
Yes, how you doing? I wasn't going to say nothing, but I disagree with the man who spoke before the young lady when he said Prop 47 is the violence is going up, or Prop 47 is for nonviolent offenders. People who are not violent qualify for Prop 47. So I disagree with that. And another thing I disagree with, like for instance, my son, he was charged with $260,000 bail. So I was scared, I was nervous, so I was calling the bail bonds, is there any way we could work this out? He said, yeah, you have to have $20,000 and we could make this work, but I think you better hurry up and get the $20,000, because if he goes to court, it could go up. So I'm panicking, I'm about to go to my credit union, and I'm about to take $20,000 out, which I don't have, but I was gonna apply for the loan. So then I go to, good thing I had a friend of mine, he was a lawyer, and he said, do not bail him out, let's wait till Monday or Tuesday, and I'll go to court with you, and I'll get the bail reduced. So I'm calling the bail bonds and tell him, no, you know, I'm not gonna come through, he said, and he was getting angry with me. So when we get to court, the bail is dropped down to $30,000. But not only that, if I would have took that loan out, and the charges were dropped, but if I would have took that loan out, I would have been $20,000 in debt for this young man not being charged. Now I'm $20,000 in debt. Then there's young men that I work with. There's another young man who's being charged, and he's a single father. He doesn't have a mother or father. He's on his own. He had to come up with the bail money. He came up with the bail money, but not only that, now the bail department is making these young men and women wear ankle bracelets. So he was also, the ankle bracelet, something happened to it, it didn't work. So the bail's bond revoked his bail, and he had to re-bail again, but there was nothing wrong with the bracelet. So I'm not here to knock it, because I'm just learning about this. But I think the bail and the bail bonds, it's a hustle, and it's to hustle poor people, and mostly people of color who can't afford this. For instance, if you take a friend of mine's mother, his bail was 30. She had to come up with 30,000, so she took a loan out for 30,000, and now she has to get a lawyer and also pay for the ankle bracelet. So he could end up homeless because he has to pay all this just because he's scared to go back to court, and these are the things that can happen. So, and also when you do go to, when you are charged, I'm not here to knock the police officers, but what they do, they charge you with 5 things, maybe 7 things, and then you find out that the bail is so high, but when you go to court, the judge will knock some of those things off. But in the meantime, you already paid for the 5 charges, like the young man was over saying, marijuana. But then he could charge you, like the man over there was saying, with all these other charges that don't even amount to what this young man or woman did. Thank you.
Thank you. Just as our next member of the public comes up to make public comment, I just want to make a note to our panelists. If you hear something that you want to respond to or amplify on or expand on, please just make a note of it, and then we'll come back and we'll have a more robust discussion from the panel. We don't have a long line of members of the public, so I want to get through them first. Next, please.
Hi, good morning, Assemblymember Bonta and Senator Hancock. My name is Tunisia Owens, and I'm the court advocate for an alternative sentencing program here in Berkeley named the Reset Foundation. And I would like to thank you for having a discussion about this very important issue, because what we have is a broken system. And what we need are long-term solutions to the problem of the cycle of poverty and incarceration that we have going on currently. And I just wanted to really get the panel to talk a little bit more about how we have long-term solutions. I think it's important to discuss the personal stories and the impact, but we also want to talk about those long-term solutions that are possible so that we can interrupt that cycle and really end this. Because we all know the stories. Many of us here have personal stories and people in our families who are impacted by this issue. And I think it's definitely very important for us to consider long-term solutions to this problem. Thank you.
Thank you.
Hello, thank you for taking my comment. My name is Dr. Prince White. I work for Urban Peace Movement, and I work with the Determination Black Men's Group. I work with what we say are opportunity or high opportunity youth. Some say, at-risk youth, those that don't have jobs or access to education. A lot of my young men are on parole or probation and have been through this very system, and I really just want to relay a small anecdote, which is that all of my young men know that if they're able to make bail and show up on their own recognizance, that they're going to get better treatment under the law, that they're going to get a different form of justice. And that's a problem. And I want us to be mindful of why we have to change a system like this. And that's because of the way it impacts boys and men of color, and specifically black men. This is, we are targets here, and this criminal justice system just treats us so unfairly, and we have to get at that core issue. And I think that dealing with this bail system is one of those important steps forward that we have to take, but ultimately we have to ask ourselves questions about who we demonize and who we vilify, which again, I will insist, it's black and brown young men, which is why we are at such a disproportionately impacted by the system of mass incarceration. So just as we press forward and we dismantle this bail system, let's think about how right now it's like, 89% of people in Santa Rita are up for bail or at least haven't been tried yet. Let's think about, as those folks aren't being housed, as we don't have to spend money on those folks for Santa Rita jail, let's think about how we could take some of that money and put it back into the system and put it into programs like the Determination Black Men's Group, like Courage over here, so that we could, or like the 1,400 jobs that we got here in Alameda County for formerly incarcerated folks and opportunity youth. Let's reinvest our money and our priorities so that we stop the criminalization of our black and brown people. Thank you.
Thank you. Seeing no more folks in line for public comment, let's come back up to the panel and start with Professor Ball. Any reactions to public comment or any additions that you'd like to?
Sure. I'm going to focus my comments on the money bail system, although I guess I can't resist saying that even though we do have speedy trial rights here, they're so often waived. I guess I'd like other comment on that, that in most cases that I saw in our court watching and that my students saw in our court watching, speedy trial is waived almost all the time. So that's certainly not what we saw in Santa Clara County, is to see preliminary hearings or things like that actually taking place within the statutory limits. But I do want to talk briefly about the comments from the bail bond agents, and thank you very much for your perspectives on that. As I said in my comments, there was a statistic from the Bureau of Justice Statistics that said the rearrest rate on OR is 17% and money bail is 16%. But as I mentioned, that's all programs that are included in OR, including no pretrial services and no pretrial screening. And the Bureau of Justice Statistics, moreover, has actually produced a data advisory cautioning people that the data that they have produced themselves has problems with it, and they suggested that people be very wary about that. So the statistic that I cited from Santa Clara County was commissioned by Santa Clara County itself with and performed by the Pretrial Justice Institute. It's local, and it's in this very area of the country, and so I think that those statistics actually are a lot more robust. I also am totally unfamiliar with any statistic that says that more than 40% of people on OR fail to appear, so I'd welcome finding out where that came from. As for the idea that bail is responsible for people who are out, as I've said, if you are out on bail and you get rearrested, the bail bond company is not penalized at all for that. The bail bond company only has to pay after 180 days when somebody didn't show up. And when somebody's showing up, what I mean by that is if they get rearrested, that counts. So if the police officers bring someone in or the person voluntarily comes in after they miss their court date, that doesn't count as a failure to appear, but that's not because of something the bail bond company did. Sometimes it is because of what the bail bond company did, but oftentimes it's not. And so we really have to think about what are the financial incentives for bail bond companies to actually make sure that people don't get rearrested. And the answer is, in our current system, we don't have any. One proposed solution that I might suggest with the Assembly member and the state senator is that bail bond companies are penalized when their people that they bail out are rearrested, or that they reimburse the police officers who take people in when they're rearrested. Those are certainly common sense solutions that would make sure that bail bond companies are internalizing the costs that they impose on society. There was a suggestion that we lower bail amounts, and I'm really glad that we actually have the opportunity to talk about this because in our study of the Santa Clara County bail bond market, again, which was made possible because Santa Clara does such a good job of publishing its data, less than 3% of bail bonds were issued, 3.8% of bail bonds in Santa Clara County in 2015 were issued for less than $2,000. And so what that means, and this is something we've actually observed from talking to other people who are in the industry, if you have a $15,000 bail set, the bail bond company is going to get about $1,500, maybe only $1,200 if it's 8%. If you have a $2,000 bail, it's really not worth their time to bail you out for just a $200 bond. And so, ironically, what we've heard from lots of people in Santa Clara County and what we can observe from the data is that if you have a $2,000 bail, that actually might be harder for you to bail out because you only have the option of cash bail. You've got to come up with all $2,000. Whereas if you have $15,000 bail, all you have to do is come up with $1,500. So lower bail amounts can actually result in this paradoxical thing where it's much harder to get out because who's going to underwrite 10% of a tiny amount? One other thing I just wanted to, two other things I wanted to talk about. One was the talk about the GPS monitor. That's just for supervised OR as far as I understand, and it's not necessarily for people who are on OR. But there are issues with GPS monitors in that they cost money typically to rent, and so there are these issues about poverty that come out even if you do have things like supervised OR. The same thing is true of drug tests. You can be charged for taking drug tests as a condition of that. In Santa Clara County, you can actually be charged for your pre-sentence report, which you need to have in order to be eligible for probation, which I also think doesn't make sense, but that's a sort of wider issue talking about poverty and criminal justice. And the last thing I wanted to talk about was the issue about racial bias and who would have bailed people out. So I do think that there are issues with potential issues with racial bias. My colleague to the left here talked about the ProPublica report about Florida and the risk assessment tool used there. And I was very troubled by that, and I've actually written publicly about that. What I think was the problem with the example of this case, where it found essentially that whites who were found low risk were more likely to reoffend than blacks who were found low risk, and that more white people therefore were being found low risk, and that black people who were high risk were less likely to reoffend than white people who were found high risk, so there was something off about the calibration. The problem that I have with that is that this is a private company, North Point, who did this risk assessment tool, and I am opposed to risk assessment tools being proprietary, not just the questions, but the scoring matrix that they use in order to determine whether someone is high risk or low risk. So I'm comforted, or I'm encouraged by the fact that the PSA court tool, which District Attorney Gascon talked about, that's being piloted in both San Francisco and Santa Cruz, is public. The scoring matrix is public. There are only 7 questions, and I think that's really important as we move toward risk assessments. The 2 things happen. First is that they're all open, and we can all understand what's going into them. And second, as I said briefly, but I'm glad to have the opportunity to amplify in my comments here, as I said briefly in my initial comments, that we make sure that there aren't disparate impacts on bases that aren't related to public safety, like race and gender. Having said that, the advantage that you have with a risk assessment tool is that all of us, every single person in this room, has implicit biases, including judges, including everyone in law enforcement. I'm very convinced by Stanford psychology professor and MacArthur Genius Award winner Jennifer Eberhardt's work on this subject, particularly when it comes to criminal justice. So the difference with risk assessment tools is you can actually look at their bias and you can correct for the bias, and you can do that, iteratively and improve them. Our implicit biases, and again, we all have them, are much more difficult to diagnose. And so the issue is not the issue is really what we're going to do about bias and what we think is the best mechanism for determining where bias exists and how we can fix them. And I think that implicit bias, because we are unaware of our own racial biases, is a lot thornier, and it's something that often doesn't get a lot of credit. So, thank you.
Thank you. District Attorney Gascon.
Yes, thank you. First of all, I want to thank Professor Ball for distinguishing the tool that we're using from those that are being used in other jurisdictions. Our tool comes from the Arnold Foundation is a nonprofit organization. The tool is widely being used, and everything that goes into the tool is open to the public, and the tool gets calibrated by jurisdictions. So one of the reasons, for instance, that San Francisco is going through a pilot program now is because we recognize that while we spent about 3 years analyzing the data with the Arnold Foundation, we recognize that now we have to further calibrate the tool for our own community and our own criminal justice system, which we are doing. I think it's important to know that there are about 29 jurisdictions now that are using risk assessment tools. And unlike some other comments that have been made here, there has not been any negative impact on the criminal justice system or public safety. To the contrary, those jurisdictions are experiencing either the same or less crime that they did when they were using a money bail system. In fact, the District of Columbia has been using a risk assessment tool for many, many years without any negative impact. I think it's also important just to set the record straight, that there is absolutely no scientific evidence to support that Prop 47 has caused any increase in crime in the state of California. Also, that Proposition 47 does not deal with violent crime. Proposition 47 is very restricted to people that are in possession of drugs for personal use, which were, quite frankly, often people of color that were being incarcerated for extensive periods of time, and people that are involved in low-level property crimes. So attaching a crime increase to Prop 47 is certainly not supported by any evidence at this point, and I think it will probably be at least a couple of years before we can make a statement one way or the other. More importantly, we have seen increases in crimes in other jurisdictions outside of the state of California in the recent year, and they are not being impacted by Prop 47, and even within California, we have seen some jurisdictions where crime has gone up, like in my own jurisdiction, other jurisdictions where it hasn't, and now in San Francisco, crime is going back down again, and still we're working under Prop 47. So I think it's really important for the public to push away for this notion that Prop 47 is increasing crime, because it has not. But what it has done is begun a process of unwinding the war on drugs that for the last 35 years has resulted in the incarceration of hundreds of thousands of people in the state, and has given criminal records to people that have been impacted in so many different ways, individually, as a family, and as a community. So let's get away from this. Quite frankly, I get a little emotional about it, but let's get away from this crap that Prop 47 is increasing crime, because it is not. Certainly, there's no evidence to support that today. 2 or 3 years down the line, we can put data together, and maybe there is areas that need to be tweaked, but those that are going around blaming Prop 47 for increases in crime are doing so without any data to support that.
Thank you, District Attorney Gascon. Let's go to John Jones III, followed by Zachary Norris.
Okay. Thank you, Assemblymember Bonta. Just a few thoughts. I hear a few words used today. Let's start with the Constitution. You know, Independence Day was yesterday, and just amazing to me that so many people celebrate a document that was written by a rich white man to benefit only a rich white man. This document said my ancestors were 3/5 of a human being. So I declare to you that just because something is legal does not make it moral. We must understand that because something is legal does not make it moral. Governor Wallace says segregation today, segregation forever. Who in this room believes that? Andrew Jackson was a slave owner, and he was racist. He engaged in policies that displaced indigenous people. There is a reason why he is being removed from the $20 bill, because nobody in their right mind or who declares themselves to be a moral human being will accept policies like that. And I want to connect that with this bail issue for a reason, because if we look at the history of police in the United States, and bail does have some history, some correlation with that. It was created to catch slaves. Let's be clear about this, to catch slaves. And there were folks who lived up north who was never a slave, but because they were black, they were kidnapped, and they were brought into bondage in the South for a profit. So when I hear public safety, forgive me, I'm a little disturbed in my spirit because I want to know, I want to ask some questions. Who in this room seen their first dead body when they were 6? Who had a Molotov cocktail thrown in their body, in their front room window when they were 7? Who was forced to stand in the street at 12 years old and forced by the police to pull your pants down and spread your butt cheeks because the assumption is you have crack cocaine hidden in your rectum? So when we talk about public safety, I never felt safe in my community. I'm born and raised in East Oakland, and I know there's some numbers I read. It's interesting. It says that white men are 35% of the population of this country, but somehow they are 65% of the police officers, and they're 95% of the prosecutors. So I have a big problem when people who don't look like me, who don't walk like I walk, who don't talk like I talk, can somehow make a risk assessment available for someone like me. When I submit to you that you are the one who's in need of a risk assessment, when we have people of color being murdered by law enforcement or law enforcement agents, when we have people in prison, not just men, but women, separated from their families for what? For draconian policies. Hillary Clinton called people like myself super predators. I find this amazing. And I want to wrap up with Prop 47 for a reason. Prop 47, my colleague John back there, we are on the Board and State of Corrections and Community Prop 47 Executive Steering Committee. And we are part of a wonderful committee that is dedicated to making sure that the funding goes to the proper people. But I want to ask something else to you. Can we talk about public safety? I was released from prison July 6, 2012, after 5 years, 30 days, 18 hours, and 47 minutes being locked up. I won my appeal. I was out for 3 years in the state of Washington. The prosecutor in the state of Washington appealed my appeal. Somehow he won. So, no, they did. Leaving a Warrior game, I was arrested and sent back to the state of Washington. Although I did not commit a crime, although I was out for 3 years, I did not have a jail walking ticket. And in fact, be patient with me. Allow me to credential myself a little bit, if you don't mind. In 2014, I worked on Measure FF, which is the minimum wage. You can go on YouTube and put in John Jones Lift Up Oakland. I worked on Measure Z, which is a public safety measure to make sure our city is safe. I worked on Measure N to make sure our school systems here in Oakland have more funding. I walk the streets of Oakland daily. Every Friday we have walks for peace. I'm working with young people now, and I'm doing all that right now as someone that's on parole. So when we talk about public safety, I'm on parole doing these things, people. I'm on parole right now, which means I'm not formally incarcerated. I'm presently incarcerated. But yet I'm out here demonstrating I am a human being, that I am conscious of my responsibility to my children, to my neighborhoods, to my communities. So I get upset when I hear folks like myself get dehumanized and demonized. I get upset when I hear that individuals are held responsible for a system that is not of their creation. This is a violent nation. You celebrated violent rebellion because people did not want to pay taxes. You got people living in third world conditions here in the United States. I was in Detroit. That city looked like it was Afghanistan. So we got to really look at our conscience. We really got to adjust our moral compass here. And above all, we got to get out this mindset that, oh, well, that's just how it is. And well, this will make us feel safe. That don't make us feel safe. You know what make people feel safe? Families being together. People having a stable roof over their head. People having access to a job. In California, there are nearly 6,000 restrictions on people with felony convictions who are looking for work. What is wrong with that? Who created that policy? Who feels safe knowing that? Who feels safe knowing that when someone comes home, chances are they can't get a job? So what do you expect people to do? I'm going to end it with this. The human instinct, the will to survive, is far stronger than the will to obey. As a parent, if I don't feed my children, if I don't give them breakfast, if I force them to miss lunch, If I force them to skip dinner, but I have some Skittles that's accessible to them, and because their hunger is so compelling, they go and they open that bag of Skittles and they eat it, and I spank them, and I send them to their room and say, you're a bad kid. They're not a bad kid, I'm a bad parent.
Thank you, John. Zachary.
I appreciate that. I was also basically born and raised in East Oakland, and so I do have a problem when people basically argue that money bail enhances racial justice or enhances economic justice. I think it's very clear that the opposite of that is true. I appreciated Professor Ball's comments also. I want to be clear in terms of my assessment of risk assessment instruments. Risk assessment instruments err. They will create errors, but bail is by definition erroneous. I think in no scenario do we believe that money is an effective proxy, is an effective measure of your public safety risk. And so when we're using bail, we're using a tool that is by definition erroneous. And I would just ask us to think about which side of history do we want to be on as Californians. From 1980 to 2000, we built 23 new prisons and just one new university in this state. And I believe it helped spark what has been the largest prison building boom in human history in this country. Finally, there's bipartisan interest and engagement in terms of criminal justice reform. And you see progressive states like Kentucky actually looking to reform their bail practices, looking to make changes. And so in that environment, we must ask ourselves, what are we doing? Are we going to actually lead, or are we going to continue to settle for the status quo?
Wonderful. Thank you. I want to be mindful of the time. We're getting close to the end of our time together. I want to give Senator Hancock an opportunity to close, and I'm going to say a few words as well. But I did just want to raise one question as we look forward and think about alternatives to money bail. We've definitely heard that one obstacle potentially is the issue of the state constitution. And we've heard from some speakers that our state constitution will need reform if we are to pursue another route besides money bail. So I want to just see if anyone disagrees with that. I'm an attorney, and definitely our Constitution and our laws are subject to different interpretations. There's different case law that applies at different times. So I don't want to have a big legal argument, but I just want to see if that's an accepted truth or if some people see it differently. So let me just flag that point, and what looks like Zachary and Professor Ball have some comments. And then my second question is, if we are to pursue an alternative model, and it definitely seems like things like having a risk assessment model that's transparent, that relies on objective factors, not subjective ones, is something that needs to be part of any other model. But if we do pursue another model, is there a place for money bail within that model? Or do most folks think that money bail has sort of had its chance and its failures far outweigh its positives, and there's not a place for it? So just want to maybe hear one person on each of those questions if you have some thoughts. And I saw Professor Ball and Zachary look like you have something to say here.
So I would say that New Jersey's recent bail reform is something that the state should really take a look at. And there they did have a constitutional amendment to do away with bail. I mean, it sort of depends on what sufficient sureties means, and I don't know if sureties is associated with commercial sureties or if it just means some kind of guarantees. I'm not sure about that. I'll leave that for somebody else. But I think what New Jersey did is good in that, one of the other things we can also look at is not only what policies we have, but the way you can adjust the burdens of proof and have procedural protections. So in the federal system, and also you have the judges are required to guarantee appearance in court by the least restrictive means possible. And that's a pretty heavy thumb on the scale, that they shouldn't just throw the book at everyone, that they are required instead. And that's our federal system, right? Is that least restrictive means possible. And I I would support something like that. Also, if somebody is going to be detained pretrial, that they have, the right to cross-examine witnesses, they have an attorney, that they, that there are other kinds of procedural guarantees that make sure that what goes on is robust. When we looked at courts at arraignment in Santa Clara County, the longest any bail hearing took was 5 minutes, and the median was probably under 90 seconds. And that's to have someone waive charges being read to them and get assigned an attorney. And only at that point does the public defender have access to the pretrial report. And so it's almost impossible for them to make any kind of finding about that. So I think we could even look at that and say, you do get another hearing 5 days later, but that doesn't necessarily do you much good. We could look at other kinds of guarantees, more robust funding for public defenders, other kinds of rules of court where we could make sure that the process does provide defendants with much better opportunities to challenge the conditions that are being imposed on them pretrial.
Just quickly, I would say that I agree with the assessment that I'm an attorney, but I'm not an expert on this issue. I agree with that assessment. My larger point is that there's a national tide against bail. We're working with Congressman Ted Lieu's office, which for the No Money Bail Act, which would basically disincentivize states who continue to use money bail by removing burn JAG funding. And I think we really need to look at the way the tide is turning, see the way in which bail has reinforced economic and racial injustice, and move away from it.
If I could just weigh in on the question of the role for money bail. It's currently, our system nominally guarantees everyone a right to bail, which has sort of become this, we sort of take that to be the equivalent of cash bail or money bail. But the way it is being used is, I think it's an open secret that bail is set high in some cases specifically to keep some people incarcerated. So we already have a system of pretrial detention, but it is not transparent. It is not based on any anything but a judge's gut, which I think we are all sort of generally in agreement we need to have a little bit more to go on. But that said, if the original point of money bail was to ensure a person returns to court, not to keep them incarcerated. So if money bail were to return to its original intent and to be it could be a condition of release. But it should never be the thing that makes the difference between a person remaining in jail or getting out, or remaining in jail or putting their family into poverty or deeper into poverty.
Wonderful, thank you. Thank you all for your comments. I want to turn to Senator Hancock for any closing comments or remarks.
Well, I've been listening and learning a lot, and I really appreciate this hearing very, very much. It seems to me that we would want to look at perhaps requiring some kind of risk assessment, and it should be open and transparent and based. I believe there are about 6 or so nationwide that have been validated and used in other states. And we should certainly look at minimizing money bail. Look at what other states have done. I thought Kentucky had also done away with money bail in addition to New Jersey. What have their experiences been? The data that I've seen on Kentucky is extremely good. Somebody cited some numbers that I don't really think are correct. In Kentucky, the failure to appear rate is only 10%, which means 90% of the people do appear, which is better than our statistics. You also, hating to say it, but I also chair the budget committee that deals with prisons and courts. You save a lot of money doing that. One county in Texas, for instance, that did that saved over $4 million. You reinvest that in your schools. You reinvest that in your programs, like some of the ones that we have here today, and we're going to get a lot more positive outcomes. And the one thing I would be interested in looking at is the participation of sheriffs and DAs and law enforcement in this. I've been surprised by the fact that I believe now, from what I've read, that plea bargaining is one of the major ways we actually incarcerate people. It isn't really going to trial. And obviously, the use of the threat of bail to get a plea bargain would be something that we would want to find a way to mitigate. And I don't know, if the DA who's here or other people, but that's a conversation that we have to have, because it really, to use the threat of bail to get a plea bargain skews the whole system, it seems to me. So I'm really very grateful that, I am termed out this year, but that Assemblyman Bonta will be here to pick up and carry this issue forward. I also think that one thing we ought to have is county-by-county data on this. There's been some barriers put in our way of getting that, but if we could find the counties that are doing it well and get them to interact with the counties that may not. Just as a quick story to close, I had a situation where someone got out of a jail in the Central Valley and committed murder. And the sheriff immediately had a press conference saying, it's Prop 47 or, realignment. At that time, it's always whatever the reform is, even though we're in the midst of a groundswell of reform across the whole country. It's realignment. So the senator from that district and I wrote a letter saying, tell us about your jail management practices. How did this person get released from jail to do this? Well, it turned out they didn't use a risk or needs assessment. This individual was mentally ill and had been in and out of jail 12 times in the previous year, no help in any way and no assessment. In that jail, they were so overcrowded because of the fact that their bail was so high that they just released last in, first out. And we were able to embarrass them into making changes. But what you do really have to look out for comments about Prop 47, Prop 36, realignment. Really, they're making our system safer, and they're putting us on the road to reform. So data, an evidence-based assessment, and a conversation among all aspects of the community, I think, are what we need to begin to heal this broken system. And thank you, Assemblyman Bonta, for doing this.
Thank you, Senator Hancock, and thank you to all of our amazing panelists for participating in today's dialogue. I thought it was a rich dialogue, very helpful comments and thoughts made on this important issue. I'm proud that we are addressing head-on this important issue of justice. And these conversations are hard conversations, but they're important conversations, and I'm glad we're having them together. And so I just want to thank our panelists again. I want to thank my staff, Amy, Max, Justin, my whole team, for everything that you did to put today's event together. I want to thank all our members of the public for participating, for being here and listening here. If you came to listen, and for those who stood up and spoke, thank you for standing up and letting your views be known, even if they were views that were different than some of the other views in this room. I think the foundation of a healthy democracy is putting all ideas on the table and engaging and participating in the process. So I want to thank you all for doing that and being here. In my view, we have a system that's broken, and I'm committed to moving forward, providing a solution. I don't know exactly what that solution is yet, but I think we need bold action, comprehensive reform. We have a system now that punishes poor people for being poor, that criminalizes poverty, that doesn't do a good job, based on all the evidence that I've seen, in assessing public safety risk or flight risk. When you put all that together, combined with the millions of dollars that we invest in pretrial detention for folks who have not been convicted of anything, we've got a major problem. And our job as legislators is to take on problems and solve them. One of the beauties of the new term limits is folks are willing to take on some of the big challenges that have been with us for a long time, that may have had solutions proposed that didn't quite make it in the past. So I want to thank our courageous, bold leaders like Senator Hancock for all the work that you've done. I'm proud if you're willing to take the handed off baton and continue your work in order to create the reform that we need. I'm committed to charting a path forward that is positive and fair and infused with justice, and I look forward to working on that with all of you. Thank you again for being here. Let's give a round of applause to our panelists and all members of the public for being here.